The archive never closes. Tonight's file, in the matter of the estate of Howard Hughes, Jr. In December of 1967, a man driving through the Nevada desert at night stopped for what he thought was a drunk lying in the dirt off Route 95. He drove him 150 miles to Las Vegas. He gave him a quarter for a phone call. 9 years later, a handwritten will appeared on a desk at the Church of Jesus Christ of Latter-day Saints in Salt Lake City. It left that driver 1/16th of the largest fortune in America. $156 million. Counsel, there is only one question in this case. Was he the luckiest man who ever lived, or the boldest liar? 7 months of trial, millions of dollars, and I am not certain the jury answered it.
Howard Hughes, Jr. died April 5, 1976, aboard an aircraft between Acapulco and Houston, aged 70. Aviator, film producer, defense contractor, the richest man in the United States. By the end, a recluse. He had not been photographed in 20 years. He lived in darkened hotel penthouses, sealed against germs, attended by a small staff. When he died, the fingerprints of the Federal Bureau of Investigation were required to confirm that the body was his. His estate, something between $1 and $2 billion. For 4 years, he lived on the top floor of the Deseret Inn in Las Vegas. The windows were taped over. He would not permit sunlight. When the hotel asked him to leave for the holidays, he did not leave. He bought the hotel. And then he bought 6 more, and an airline, and a mining company, until a quarter of the Las Vegas Strip belonged to a man that none of its employees had ever seen. And he left no will. None that anyone could find. Not one. The richest man in America, and no instrument disposing of a single dollar.
Understand what that means, counsel. An intestate estate of that size is not a vacuum. It is an invitation. Within months, more than 30 documents purporting to be the will of Howard Hughes had been filed in courts across the country. 40 by some counts. Most were absurd. Most were dismissed in an afternoon. And then, on the 27th of April, 1976, 3 weeks after the funeral, a clerk at the headquarters of the Latter-day Saints in Salt Lake City found an envelope on a desk. Nobody saw who left it. You should understand what arrived in those Nevada courts in the months after his death. A will written on the back of a hotel menu. A will that left the estate to a woman who had never met him. A will produced by a man who claimed to be Hughes's secret son and who could not name the year of his own birth. Clerks stopped counting somewhere past 40. Into that circus walked the document we are here to examine. And unlike the others, it did not die in an afternoon. 3 pages, yellow legal paper, written entirely in hand, which matters, counsel, because Nevada recognized the holographic will. A will written and signed in the testator's own hand needs no witnesses. No lawyer, no notary, no ceremony, just handwriting. Counsel, permit me a moment on why such a document is lawful at all. The holographic will exists for the soldier in the field, the miner in the shaft, the man who knows he is dying and has no lawyer within 100 miles. The law says to him, "Your own hand is enough. We will trust your handwriting because we cannot send you a notary." It is one of the few places where the law bends toward the poor and the isolated. And it is precisely that mercy, that opening left for the desperate, that a forger walks through. The document divided the estate into 16ths, to his ex-wives, to his aides, to the Boy Scouts of America, a 16th to the Mormon Church, which was strange because Hughes was not a Mormon, though many of the men who guarded him were, and 1/16th to a name nobody in the room recognized. Melvin Dumar of Gabbs, Nevada.
Melvin Earl Dumar, 32 years old. He ran a service station in Willard, Utah. He had worked as a milkman, a butcher, a laborer. He was, at the time the will surfaced, in debt. And his surname was misspelled on the document.
Now, hold that detail, counsel. A forger writes the name of his beneficiary correctly. Or does he? A forger who is himself the beneficiary might misspell it deliberately to look innocent. Every fact in this case cuts both ways. That is what made it a 7-month trial. 7 months. Understand the scale of that, counsel. The estate spent millions. It flew in handwriting examiners from 3 countries. It hired investigators to trace every hour of Melvin Dumar's life in December of 1967. On the other side sat a service station operator from Willard, Utah, and the lawyers willing to gamble on a contingency. The scales in that room were not level. They were never going to be. 1978, Clark County, Nevada, the courtroom of Judge Keith Hayes. Dumar tells his story. December 1967, driving at night on Route 95 near Lida Junction. He sees a man lying in the dirt, face down. He assumes he is drunk. He stops. The man is thin, filthy, bleeding from one ear. He does not want a hospital. He wants Las Vegas. Dumar drives him 150 miles through the dark. They barely speak. He drops him behind the Sands Hotel. And only then, as he is getting out, does the man say, "I am Howard Hughes." Dumar says he laughed. He gave the man a quarter for the payphone, all the change he had, and drove home. And told the story on and off for 9 years to anyone who would listen, long before there was any fortune to claim.
And under cross-examination, Thorne, the story acquired detail it had never had before. Suddenly he recalled the make of the car, the weather, the exact words. A memory that improves for 9 years is not a memory, it is a construction. That is the defense of every confidence man, Thorne, that he laid the groundwork so far in advance it cannot be a scheme. Look at the document. The estate hired the finest questioned document examiners in the world. Their conclusion was not close. The handwriting did not match Hughes's hand in the relevant period. His writing had changed before the date this will claims to have been written. It was, in their words, a crude forgery. And the envelope. Do you know where the questioned document had been, Thorne? A fingerprint on it belonged to Melvin Dumar. He testified he had never touched it before it reached Salt Lake City. That was a lie, and he admitted it on the stand. He said he had found it at his gas station and delivered it himself, and had been afraid to say so.
I have watched innocent men lie in a witness box, counsel. They do it for the same reason guilty men do, because the truth, said plainly, sounds worse than the lie. A poor man finds a document worth $156 million on his counter. He knows precisely how that will sound. So he drives it to Salt Lake City, leaves it on a desk, tells nobody, and prays it will be found without him. That is either the act of a forger covering his tracks, or the act of a frightened man who understood exactly how little his word was worth. The jury had to choose, so do you. He lied. That is not in dispute. He changed his account under oath, and a man who changes his account under oath has handed the other side its closing argument. But counsel, a lie about how a document traveled is not proof of who wrote it. Those are two different questions. Juries are not always careful to keep them apart. And here is what the jury was never shown. Hughes's own aides testified he never left the penthouse, that he could not have been in that desert. Those aides were employees of the estate, the same estate that stood to lose $156 million if the will was upheld. Their salaries depended on the answer.
Then explain the paper, Thorne. Explain why a man worth $2 billion dictating the disposition of an empire wrote it on a legal pad in pencil, misspelled the name of a beneficiary, and left it in an envelope on a stranger's desk. You call that mercy for the isolated? I call it exactly what it looks like. Every witness in every case has an interest. That is what cross-examination is for.
And every juror in that room had spent 9 months being told by newspapers that a gas station attendant was trying to steal a billionaire's fortune. Cross-examination does not reach that. Counsel, the jury is back. June 1978, the Mormon Will is declared a forgery. Melvin Dumar receives nothing. The jury deliberated for 8 hours. 8 hours after 7 months of evidence. I have never known what to make of that number, counsel. It is too short for men wrestling with a genuine doubt. It is exactly long enough for 12 people who had made up their minds in the first month and needed the afternoon to say so politely. And then, the strangest fact in this file, no criminal charge was ever brought. Not against Dumar, not against his wife, not against anyone. A jury found that a document was forged, and the state of Nevada never once asked who forged it. Consider what that silence means. Either they knew and would not say, or they had a verdict they could not have proved beyond a reasonable doubt. Dumar went back to Utah. He drove a truck. He sold frozen fish from the back of it. A film was made about his life, and it won 2 Academy Awards, and he was paid almost nothing for it. He filed again in 2006. He lost again. He died in 2018, still telling the same story he had told in 1967. In 2005, a retired agent of the Federal Bureau of Investigation published his own investigation. He found a witness who placed Howard Hughes near Lita Junction in the desert in the winter of 1967. He found a man who said he had flown Hughes there. It changed nothing. The judgment was final. Final is not the same as correct. It only means the courthouse has run out of doors. I have read this file more times than I can defend. And what troubles me is not that the jury found a forgery. On that evidence, 12 reasonable people could reach it. What troubles me is that the trial asked whether Melvin Dumar was believable. It never really asked whether Howard Hughes was in that desert. Those are not the same question. The first one, a poor man in a cheap suit was always going to lose. The law is what we wrote. Justice is what we wanted. I am condemned to read the difference, one case at a time. Next week's file, a man was convicted of a murder. Then the victim walked into the courtroom. The cold corridor is waiting. If you would like to study the evidence the way counsel does, the case brief is in the description. Filed, never forgotten.